we are seeing a popular uprising in virtually every corner of the country of a very unusual kind. It is an uprising in defense of our finest constitutional values and the values that drove the freedom struggle. It is an uprising that demands from the state that the state should not divide us on the basis of religion. I think that at the gut level, people across the country understand what the CAA, NRC, and the NPR stand for, what they're doing, what they intend to do to the Indian nation and to Indian society. There is also a resounding resolve to meet the state's determination to implement the CA, NRC, and NPR, and its intensely divisive implications, its implications which are destructive of the Constitution, with a massive program of civil disobedience. But while people, I think, understand both the moral and the political and the constitutional implications of the CA, NRC, NPR, we get an understanding from our travels around the country that there's a lot of confusion with the detailing of especially the legal implications and details of this alphabet soup in which the country has been thrust. And therefore this public hearing, we've called it very early in the year, it's been called very fast, but we felt it was necessary because the government is responded, of course the Prime Minister responded with extraordinary, an extraordinary economy with truth, to put it lightly, when he said in the Ramlila grounds that his government had never even considered the NRC when the Home Minister has spoken about it multiple times in Parliament and outside, and that there are no detention centres. The Home Minister then said there are no detention centres, etc. But it is, it was indicative of a whole campaign of misinformation and disinformation in order to respond to the popular upsurge and revulsion against the CA, NRC, NPR combined. So this public hearing is really intended to begin or to contribute, actually there's a great deal that has already happened, to contribute to the process of public discussion and public education and information.
The Citizenship Amendment Act 2019 represents a definitive moment in the evolution of the law on citizenship in India. We're being repeatedly asked to appreciate its enabling character, its compassionate character, and to pretend that its disabling effects are simply a figment of our diseased liberal imaginations. But in the last few weeks, we have seen ordinary citizens, young and old, sitting in and marching to defend a certain idea of India and its constitution against this amendment. I think even the posters, the slogans, and the songs from these protests are quite enough to establish that the CAA, NRC, NPR constitute what one might call an unholy trinity. Now, the broad contours of the issues at stake are well known by now. In a nutshell, as I see it, the CAA offers paths to citizenship for groups that are favored, and the NRC, or its placeholder temporarily, the NPR, carves paths to statelessness for groups that are disfavored or objects of prejudice. We've been asked to appreciate the chronology, so I will respect that. An amendment of less than 100 words to an ordinary statute has managed to unsettle the basis of nationhood and citizenship without a constitutional amendment. So why do I say, and why do we all say, that the CAA implies a foundational shift in the conception of the Indian citizen, embodied in the Constitution, but also in the Citizenship Act of 1955. It does so in two ways. Of course, the lawyers will weigh in on this with much greater depth, but I want to signal a couple of points here. First, it entrenches a certain shift from soil to blood as the basis of citizenship. It is true that the Citizenship Act of 1955 recognizes both soil and blood as bases of citizenship. It is also true, however, that such a shift had begun to occur about 15 years ago, but this law consolidates and entrenches it in a quite unprecedented way, and I'll say more about that in a minute. Secondly, what this amendment does is it openly introduces a religious category into a law that was largely, which was religion neutral until now. There are two amendments I'd like to draw your attention to, which were legislated in 2003, came into force in January 2004, one to the Citizenship Act and another to the rules appended to the Citizenship Act, both of which show how religious identity as the basis of legal citizenship has been gaining ground for a long time. Both of these introduced religion, one impliedly, the other explicitly, into the language of the law. The amendment to the Citizenship Act covertly introduced a religion-based exception to the principle of citizenship by birth. It effectively undercut the jus soli or soil-based, birth-based idea of citizenship by saying that even if born on Indian soil, a person who had one parent who was an illegal migrant at the time of his or her birth would not be a citizenship by birth, would not be a citizen by birth, would not be eligible for citizenship by birth. Since most of the migrants from Bangladesh, against whose arrival there had been so much ferment in Assam, were Muslims, the term illegal migrant encoded and signaled this religious identity. Simultaneously, the citizenship rules were amended to exclude what were called minority Hindus with Pakistan citizenship. They were excluded from the definition of illegal migrants. This destigmatized Hindu migrants, most of whom had come in to the border states of Western India, Rajasthan and Gujarat, by dropping the label of illegal migrants for them and officially describing them in the rules appended to the Act as minority Hindus with Pakistan citizenship. The very admissibility of the idea that it is acceptable to discriminate on the basis of religion for determining citizenship seems to strike at the root of everything the Indian nation-building project and the Indian constitutional project have stood for all these decades. In September 2015, the passport rules, the Passport Entry into India Rules 1950 and the orders under the Foreigners Act 1946 were amended to exempt the very same religious groups as the ones mentioned in the CAA from the requirement of holding valid passports and visas, and consequently exempt them from being prosecuted or deported. Both these amendments refer to, quote, persons belonging to minority communities in Bangladesh and Pakistan, unquote. Afghanistan was not included here, but quote again, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution, unquote. In March 2018, the Reserve Bank of India made some amendments to the FEMA regulations by which, again, a person being a citizen of Afghanistan, Bangladesh or Pakistan, belonging to minority communities in these countries, the same communities, residing in India on long-term visas, may purchase one residential immovable property for self-occupation and may purchase one immovable property for carrying out self-employment, and then subject to following conditions. So this is an ongoing story. These groups, these countries have been mentioned in various ways in various rules and orders emanating from government over the last several years. We need to be aware of this covert history of protective coverage being extended incrementally to the same groups from the same set of countries. And of course, as you all know, it is paralleled by predictable exclusions. So, as an aside, in 2 out of these 3 countries, that's Pakistan and Bangladesh, whose nationals are excluded for purposes of the OCI status, there are Indians living in India who were once married to individuals from one or other of these countries, but who are unable to get OCI cards for their children because of this exclusion. So instead of making our citizenship regime more inclusive, we are actually and have been working overtime to make it more exclusionary. In some, discrimination based on religious identity having already found its way into the rules and orders relating to passports, foreigners, and foreign exchange, and so on, regulations has now found its way into the law on citizenship. Why do we consider this wrong? We consider it wrong because the great civilizational diversity of this country makes an inclusive and secular architecture of governance an imperative. And our constitution has recognized this in multiple ways, whether it is through reservations for historically disadvantaged groups, whether it is through rights for cultural rights for religious minorities, whether it is even the federal arrangement based initially on language, recognizes this diversity and seeks to embody it in an inclusive architecture, a non-discriminatory architecture of governance. Okay. Today, all of this has been perhaps irretrievably undermined, and unless judicial, one might even say judicious breaks are applied, we would be hurtling towards an ethno-national state in which gradations of citizenship are acceptable. From a political perspective, this implies a tectonic shift from a civic national to an ethnic national, ethno-national conception of the Indian political community and its terms of membership. Because what is citizenship ultimately? Ultimately, citizenship is about membership in a political community. If equality of citizenship, if equality of membership in a political community is undermined, we end up differentiating between classes of citizens, even possibly creating a hierarchy of citizenship, and with it, a hierarchy of rights and entitlements. In terms of a distinction between what political theorists call formal and substantive citizenship. The poor, minorities, Dalits, Adivasis, all enjoy the formal status of citizenship, the legal status of citizenship. In that sense, we are all equally citizens of India, all of us, but also others who are not in this room. But for these groups, substantive citizenship, the ability to meaningfully exercise the rights that accrue to citizens, is far from realized and has been a work in progress for many years. People like Harsh, whether it's the right to food campaign, whether it's the right to education, all of these advances have been made over the past few decades, seeking to make formal citizenship, legal citizenship, more real and more substantive. That has been the direction in which we have been moving. Given the marginalization, given the vulnerability of these groups, given the convergence between poverty and lack of documents, given the histories of prejudice in our society, these groups more than others will, through the instruments of the CAA, the NRC, and so on, be pulled backwards. They will perhaps even be deprived of the formal legal status of citizenship. We were working towards ensuring a fuller realization of substantive citizenship for people who were formally and legally equal, but in every other sense unequal. We are now taking a step back from that and moving perhaps, this is a move from a substantively second-class citizenship to what could well become a substantively a formal, to formal legal second-class citizenship or worse. from an enfranchised status to potential disenfranchisement. And if nothing else, this at least should bother our conscience. Thank you.
So to start briefly, there are three sets of criteria that the amendment puts forth for people to qualify within its protective scope. The first is it picks out certain countries, Afghanistan, Pakistan, Bangladesh. The second is it picks out certain communities, Sikhs, religious communities, Hindus, Sikhs, Jains, Christians, and so on. And the third is it has a cutoff date. So 31st December 2014, the individual must have come to India before that. So this is not a law that seeks to grant prospective immunity to people who might now come to India fearing persecution in these countries. What it does is it takes it takes persons who have been in India before 2014 and divides them up based on their countries of origin and their religious community. So that's, in a sense, what the law is about. For those who fall outside its scope, the old 2011 SOP regime applies, in which you must establish on a case-to-case basis your persecution in your country of origin, and then you will qualify for a long-term visa. So this amendment basically has a two-tiered structure. If you fall outside it, you have a less beneficial regime that applies to you. And if you fall within it, you get greater benefits under the new regime. So that's the kind of difference it brings about. And that, of course, raises an Article 14 issue. Is this equal treatment? Because Article 14 applies to all persons in India, not just citizens. So whenever the state draws a classification and picks out certain people for favorable treatment, that attracts Article 14 and that becomes an Article 14 issue, because equality, of course, is a universal concern, not just limited to citizens already. With that in mind, let's address these three issues. So first, of course, is that this law, so the argument is that it is inclusive, it brings in certain communities that have been facing persecution and gives them protection. Now, to the extent that it picks these communities, obviously it is inclusive, but it also excludes communities that have faced similar kinds of persecution. Obvious examples being the Rohingya Muslims in Myanmar, who have been subjected to genocidal levels of oppression, Tibetan political refugees, Tamils in Sri Lanka, and so on. These are arguments that have been heard for a long time now. So therefore, the law is both inclusive and exclusionary as well. And it's the exclusionary aspects which are troubling. So the complaint is not that why are you extending immunity and citizenship to certain communities. The complaint is why are you leaving some out. And so the argument therefore is for more inclusiveness and not less. That's the first issue. The second issue, and this is the really core constitutional issue, is that when this law picks out religion and country of origin as the twin bases of extending immunity from prosecution as illegal immigrants and the citizenship path, what it does is that it discriminates between people on the basis of characteristics that they cannot control. So which country I come from, what community I was born into, are two factors that are completely beyond my control, much like race, caste, and so on. And so when you pick out these really core categories and single them out and use them to give beneficial and non-beneficial treatment, that creates an equality problem. Because effectively you're telling people that if you were lucky enough to belong to a certain community or to a certain country, then this law will protect you. And if not, you go out. Right? And so, independent of all other aspects, independent of all concerns about the politics of it, the religious character of it, and so on, just this simple fact of dividing people on the basis of characteristics they can't control is what causes an Article 14 issue, an equality problem and a constitutional matter for concern. So that is really the core issue. Now, one thing that has been brought forward often is the argument that if a law is merely under-inclusive, that can't be a ground to challenge it in Article 14. So the state can have discretion to pick certain people, it can have discretion to not protect everybody at the same time, right? And so mere under-inclusion cannot be a ground to challenge a law on Article 14 basis. Now, it's true that the court has in the past said that under-inclusion is not in itself, may not always be a basis to challenge a law. But the courts also said that under-inclusion must be nominal. So if you are trying to bring about a reform law, and because the law is a blunt instrument, language is a blunt instrument, so you can't draw precise lines, and therefore there might be some things that fall on either side of the line. That kind of under-inclusion, yes, the court can let it go, because that is inherent in the exercise of lawmaking, it's inherent in the limitations of language. But this isn't the case of that kind. This is a case where you're taking individuals, groups, and communities and saying, look, you don't qualify, but you qualify. So this isn't simply a case of imperfect drafting, the complexities of the world causing an issue of under-inclusion. It's a clear separation between categories and groups, privileging some and not others, on basis they can't have control over. And that's why this whole argument that simple under-inclusion is not a good enough ground for a constitutional challenge is clearly misplaced, because what the ground here is that people in India are being treated differently on unjustifiable bases and grounds, and that's why Article 14 becomes important. Now, the third and last point is this privileging of religious persecution over other kinds of persecution, which is also an issue. So now, of course, the Act itself does not mention religious persecution, but if you go back to the passport orders and the foreigners rules, which the Act refers to, then you get a clear sense that the stated objective of the Act is the assumption that minority communities in neighboring countries that have a state religion are subjected to religious persecution, and that gives them a specific claim to immunity and citizenship. Now, this whole idea of there being other communities that are also persecuted, and that's been debated multiple times, I think, and that of course is a valid argument. But I think beyond that, the core issue here is that persecution can take many different forms, which is why the Refugee Convention talks about a well-founded fear of persecution giving a ground to asylum claims. Persecution can be social, it can be caste-based, religion-based, and many other forms as well, gender-based and so on. And so when this law picks out religion as a form of persecution that is particularly salient and deserving of a protection other forms are not given to, then that is what strikes at the secular character of both the law and the constitution. Because there's no reason why a Tibetan who's been subjected to political persecution in Tibet, persecution that is every bit as severe and has every bit as severe consequences as other kinds of persecution, is told, you are not worthy of the state's special protection, but others are. Right? And that's why when you make religion as the basis of granting special claims to citizenship and to immunity, you are striking at the secular character of the constitution, and that's why this is a problem beyond just the picking out of certain communities, the picking out of certain countries, and these are all problems. But even beyond that is a deeper issue of making religion as the arbiter of persecution that is worthy of the state's protection. So I think that going beyond the existing debate, these three issues are additional reasons why we should oppose the CAA on constitutional and humanitarian grounds.
Now, the Citizenship Amendment Act is a dangerous legislation which runs contrary, as we have heard, to the basic principles of the Constitution and its secular ideals. It seeks to redefine citizenship by introducing for the first time a religious criterion for the determination of citizenship. This is at odds with the constitutional framework that confers equal rights on all citizens, regardless of caste, creed, tribe, or gender. The open espousal of a religious test for citizenship has divided the country as nothing else has done in decades. However, the government is going ahead with the CAA despite opposition in Parliament, despite large sections of public opinion and people across the country opposing it, and as has just been said, we are witness to the biggest civil disobedience, opposition, or protests in defense of the Constitution and against this act. Now, the citizenship law was amended to fast-track citizenship to non-Muslim refugees from Pakistan, Bangladesh, and Afghanistan on grounds of religious persecution in their respective countries. The key issue, as Gautam Bhatia, I think, just pointed out, is why does the list of minorities include only those from Pakistan, Bangladesh, and Afghanistan? Apart from the dubious assumption that Muslims are not persecuted in Islamic countries, when they clearly are, Ahmadiyya, Shias, and individual critics are examples of this. This arbitrary listing of countries of origin is striking in what it leaves out. Sri Lanka, Nepal, Bhutan, Myanmar, and China find no mention. Sri Lanka and Myanmar are particularly stark omissions because of the many Tamil refugees who've come to India in the recent past and the exodus of Rohingyas after their massacre in the Rakhine province in Myanmar. There can be only one reason why a government would exclude persecuted Hindu, such as Tamils of Sri Lanka, from the list, because their oppressors are not officially Muslim or official representatives of Islam. Clearly, the idea is not simply to help persecuted minorities, but also to demonize and isolate one group. Consequently, only this group is singled out for hostile treatment. What is significant is that this legislation recognizes Muslims exclusively as a group of perpetrators or oppressors, but does not recognize them as victims. That's the logic of singling out 3 Muslim majority or countries or Islamic countries. The point of this exercise is not inclusion, but exclusion. I think that's the critical point. Now, the main provisions of this act fail to make a meaningful categorization. Equal protection of the law, envisaged in Article 14, is that the basis for classifying a group for a particular kind of treatment should bear a rational nexus with the overall objective. Now, if protecting persecuted minorities in the neighborhood is the overall objective, then the classification and exclusion of some countries and communities using religion is patently unjust and might well fail the test of constitutionality. Secondly, it's hard to establish that refugees coming to India are fleeing religious persecution. In fact, there's just an article today in the Indian Express which clearly points out that most of them are really economic migrants or economic refugees. None of them have claimed at the time that they entered India illegally that they were being persecuted, nor have they made any such claim to any authority in India since then. In fact, there were some interviews quite recently on NDTV, just last week, of people who have been recently granted citizenship and they're living in Rajasthan, and none of them mentioned religious persecution. And in fact, 2 of them clearly said that we are here because our relatives are here, our family is here, and that's why we want to live in India. So, as I said, none of them have made any such claim to any authority since then. How the BJP government in 2019 has come to the conclusion that all non-Muslims were persecuted when they illegally entered India, whereas no Muslim is ever persecuted in this country, is unclear. Thirdly, under the NRC, which is of course related, notwithstanding protestations to the contrary by the Prime Minister and the government, millions of Indians, it seems to be very much on the anvil. So under the NRC, millions of Indians would have to prove their Indianness. But the onus is on individuals to prove that they are not outsiders or infiltrators, or as our Home Minister likes to call them, Ghuspaitias. But with the new citizenship law, everybody gets a free pass, except Muslims. Any government now, once NRC is in place, any government will be able to legally single out Muslims for investigation, because after the CAA, the only category of immigrants likely to be declared illegal will be Muslims. Fourthly, and I think this is a significant point, which is that the principle of religious discrimination, once introduced, will not be limited. It will extend to other spheres. We have seen this in the blatant discrimination and brutal violence unleashed in Uttar Pradesh by the Uttar Pradesh government in response to the anti-CAA protests. And I see the response of the UPA government as part of that whole system of discrimination which is being put in place. On December 19th, soon after the protests broke out across the UP against the CAA, Chief Minister Adityanath Bisht promised or threatened that his government would take badla against protesters and auction off their properties. And he's been true to his word. Last week, people across the state were served notices demanding monetary damages for alleged acts of vandalism of public property. Finally, now the CAA will create and deepen communal divisions and social polarization. It is imperative that this agenda is countered. This can be done in 3 ways. Sustained countrywide protests involving a cross-section of the opposition and civil society over the new citizenship law is essential to foil these divisive moves. At this time, it's important to emphasize that this is not a fight for Muslims. This is not a fight for Muslim rights. It's a fight for democracy and secularism. Second, while citizenship is a central subject, and state governments, as we've been repeatedly told, have little room for maneuver, and yet, when chief ministers oppose a central law or stop NPR and NRC, they're making an important political and symbolic point, which the center in a federal democracy would normally be hard put to ignore. At least 7 states, including NDA-ruled Bihar, have announced that they will not implement the CAA. In the wake of recent protests, West Bengal and Kerala governments have announced suspension of NPR work. I think all non-BJP governments should do the same. They need to do the same. The resolution, I believe the resolution passed by the Kerala Legislative Assembly just a couple of days ago against the CAA is an extremely important move in this regard. It is a reflection of the discomfort that significant sections of the population and states have about the BJP's ideological project. And this is an ideological project. It's much more, it's not just about citizenship, but it is about, as was said, it's really changing, it's about changing the very idea of India. So, and states have about the BJP's ideological project to redefine India as a Hindu nation through the CAA. Finally, public protest and opposition from state governments can have some impact, or so we hope, on the Supreme Court. In this event, the court's rejection of the CAA would hinder the NRC and NPR. Thank you.
NPR is not NRC or National Register of Indian Citizen. NPR and National Register of Indian Citizens are indeed different, but very closely connected to each other. If we make a list, how many oranges we are having, how many apples we are having, how many bananas we are having, how many mangoes we are having, one consolidated list. Now to get the list of oranges is a click away. Once this current NPR, which will be on from April 1, 2020 is made, getting into National Register of Indian Citizens will be a click away. It will be entire digitized data. Of course, NPR will also include non-citizens, but we can exclude them. And that is the problem. And that is why the criticism of even NPR. Let us look at it legally. NPR, if it is part of census, should be under the Census Act. Neither under the Census Act of 1948 nor under 1990 census rules you find a reference to NPR. NPR and census are considered two different entities and distinct activities even by the government of India. And that is why separate allocation of money. So for NPR, Cabinet has approved 3,941.35 crore and for census 8,754.23 crore. The 2020 NPR is asking questions which are relevant to determine citizenship when it is talking about your parents' date of birth and their place of birth. as many as 8 new questions are there. I think Government of India should quickly drop those 8 questions so that immediately there is a sense of calm and contentment in the country. Now these NPR, if it is not done under Census Act, under what law it is done? It is done under Section 14A of Citizenship Act. It was inserted in this act and in 2003 for issuance of national identity card. And it says that the central government may compulsorily register every citizen of India and issue national identity card. Then under this 2003 rules very clearly provide in Section 3 that the Registrar General of Citizen Registration shall establish and maintain National Register of Indian Citizens. Then they say what the National Register of Citizens will contain. In the same section, same rule, Rule 3, we find Sub-Rule 4, central government may by an order issued in this regard decide a date by which the population register shall be prepared by collecting information relating to all persons who are usually residing within the jurisdiction of local registrar. Therefore, NPR is a sub-rule of the same rule which is talking of National Register of Indian Citizens. In 2003, the Citizenship Registrations of Citizens and Issue of National Identity Card Rules 2003. Then in Rule 4, which talks of preparation of National Register of Indian Citizens, again a reference to NPR comes in when it says for the purposes of preparation and inclusion in the local register of Indian citizens, the particulars collected of every family and individual in population register shall be verified and scrutinized. The exclusion will start at this stage, and that is problematic. Moreover, National Population Register or NPR is nowhere mentioned in the text of Citizenship Act. And whatever is not in the text of the Act, rules cannot really provide for that. Rules are after all, subordinate legislation. Act is a parent legislation. Subordinate legislation or rules cannot go against the parent act. And therefore, I feel that this mention of National Population Register should ideally be deleted from 2003 rules. Therefore, to conclude, I can say NPR and NRIC are distinct but very closely related to each other. You cannot prepare National Register of Indian Citizens without National Population Register.
The impact of the CAA, the NRC, other recent internal decisions on our external situation, our image abroad, and on our foreign policy. Because what has happened as a result of, well, the last year or so especially, is that we are increasingly isolated. There has been no meaningful international support for this series of actions that we've been discussing today. Apart from a few committed members of the diaspora and a ragtag bunch of Euro MPs from the extreme right. And this isolation is really increasing. If you look at what's happening abroad, the list of critical voices abroad is quite long, from President Macron to Chancellor Merkel to the UN High Commissioner for Refugees, to visitors like the King of Norway and so on, who would normally be polite. The UN High Commissioner for Refugees for Human Rights, for instance, has condemned the CAA, calling it fundamentally discriminatory in nature. But it's actually a cumulative effect of a series of actions. The same UN High Commissioner for Human Rights had also expressed extreme concern about the situation in Kashmir, and said that, and urged that India rapidly restore the rights that are currently being denied. And we seem to know that we are isolated. EM ducked a meeting with the heads of the two foreign affairs committees in the US Congress because an Indian origin representative, the only Indian origin woman actually in the House, was going to be present, who has tabled a resolution which is critical of the CAA and of several recent actions by the government. Rather than attending the meeting and rebutting these charges, we chose to duck this. And one result of our recent actions, including saying Ab ki baar Trump Sarkar at Howdy Modi, is that we have actually broken the bipartisan consensus that used to exist in the US, at least existed for the last 25 years, NDA, UPA, doesn't matter, on improving India-US relations. All the significant Democratic presidential candidates have spoken out on these issues. There have been hearings held in the US Congress. Language on Kashmir has been inserted into the annual Foreign Appropriations Act for 2020. And the resolution which Pramila Jayapal has introduced now has 29 co-sponsors, including Republicans and the only Indian origin lawmaker who attended the Howdy Modi conference. So the question arises, why is this? Are we in violation of our international commitments? After all, India is a signatory not only to the Universal Declaration of Human Rights, but since 10th April 1979 to the International Covenant on Civil and Political Rights, 1966, and the International Covenant on Economic, Social, and Cultural Rights, 1967. You be the judge. Article 2.1 of the International Covenant on Civil and Political Rights says, each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Notice it's for all persons under your jurisdiction. It's not for citizens, this prevention of discrimination. There's a very similar article in the International Covenant on Economic, Social, and Cultural Rights. So, secondly, not only is it not confined to citizens, and applies to all persons present on the territory, it also prohibits discrimination on grounds of national origin, which, as you've just heard, is exactly what the CAA does. All the knowledgeable people that I have spoken to agree that we seem to be in violation of our international commitments. And for those who think that the law is an ass, that in any case international law cannot be enforced, you must consider the political and other consequences of being perceived as violators of international law and of not keeping our word. Global public opinion on India has shifted in the last few months. Look at the media abroad. I mean, the criticism in the West comes from the extreme right, the Wall Street Journal, all the way to the Guardian and other leftist sort of papers, includes almost everybody in between, New York Times, Washington Post, and so on. Some in India, supporters of the bill and the act, have drawn comfort from official media in authoritarian states. To them, one can only say, be careful what you wish and whom you hug. Even our friends have been taken aback. The Bangladesh Home Minister is quoted in a Bangladeshi paper as saying, when asked what he was going to do about the NRC, CAA, and threats of deportation to Bangladesh, let them fight among themselves. Is this what you want? If this is how our friends feel, think of how happy we make our adversaries. What we have achieved in the recent past is to hyphenate our image with Pakistan's in a fundamental way, as religiously driven and intolerant states. Kashmir has been discussed in the UN Security Council again after 40 years, and we've lost, in a sense, India's ability to be an example and a model for other countries in the subcontinent, as we were during the freedom movement and in the early years of the Republic, and immediately after radical reform started working in India in the 90s and the first decade of this century. We have gifted our adversaries platforms from which to attack us. At the very least, this inhibits investment, because investment is an act of trust and of faith in the future. Our ratings have declined. 7 countries have issued travel warnings. None of this helps us. It's one thing to go it alone in pursuit of national goals, as we did in 1971 when assisting the birth of Bangladesh. But then we had global opinion on our side. It's quite another to do so in the pursuit of sectarian, divisive, and party political goals, as we seem to be doing now. What the world thinks matters more to India now than ever before. More than half our GDP is the external sector. We depend on the world for energy, capital, technology, markets, essential raw materials, fertilizers. 80% of our imports are maintenance imports. So disengagement or going it alone is not an option. But we seem determined with actions like this to cut ourselves off and isolate ourselves. This can lead to no good end. Thank you.
First, on citizenship, as Professor Jayal quite correctly told us, it's basically a political concept. A citizen is part of a political community. Whether you talk of ancient Indian city, ancient Indian or Greek cities, or a Gram Sabha in a village, or whatever. And of course, there may have been restrictions then on who's a citizen, who's not a citizen in that particular locality. But the idea of universality of citizenship, the universality as that any person who is an adult living within this territory is a citizen of that country, came with the French Revolution and is a central part of our Constitution. So when the Constituent Assembly decided in 1947 that we are going to have universal suffrage, now that was a major move, because the 1937 electoral rolls were covered barely 20% of the adult population and were divided by community. So the instruction went out that create a universal electoral roll. What I want to stress is that the reaction of the system, of the bureaucrats to that, was inclusion. They said, we've been told to create a universal roll, so we cannot leave out anybody who is a legitimate resident of this country. And they struggled to put that into practice. There was a collector in Bombay who raised the question that how do I include people who sleep in the streets or in the staircases of buildings because they don't have an address. In an electoral roll, you have to have an address. That is when the convention developed in India of attributing to these people an address which is the nearest building from where they sleep. The whole attitude was include, include, include. That was the way the system reacted. And that is why I think it played a huge role in actually creating this sense of political equality. That the universal suffrage created a sense of political equality. Some of you who are probably as old as I am would know that the early elections, the way in which people went to vote in that election. I know in my village, the people, particularly poor people, would put on their best clothes. They would put on their best clothes as if they were dressing for a wedding and line up for that election. This is the important point, that citizenship as a right of participation in a political process gave people a sense of equality, at least once in 5 years, if nothing else. So I think this is the point that I think we need to emphasize, that what we are doing now is a departure from that sense of inclusiveness, of bringing people in, of equality, of non-discrimination, which was a foundational principle of our constitution and of the way in which citizenship was defined. This is the definition of who is an Indian. Anybody who lives legitimately within the territory of what is India is an Indian. End of story. No religion, no race, no ethnic issue or anything of that sort. This was, of course, internationally there are a variety, there are no standard rules on citizenship, but it is rather unusual to deny citizenship to somebody who is born within a country. It is not common, it is not unknown, but it is rather unusual. And that is what we are in effect doing with our rules. By saying that if even if it's a person who is born within the country, if your parents cannot establish that they were legitimately within the country, you cannot get an Indian citizenship. So there are no standard rules, there are no set of principles which every country has to follow. But some of the things that we are doing do require a departure from these international standards, but most important, a departure from where we started in 1947. That is the most important issue. What do you do then about the other two issues, the immigration issues, two issues on immigration, which I'll quickly pick on. And one is the whole issue of how do you handle people who want to come into your country to seek asylum. This has been a problem in many countries. It is certainly a problem which Europe is coping with now. But I have known of no case where the rules on asylum are linked to religion. They may be linked to the possibility of persecution and establishing that. But I know of no case internationally where it has been linked to the idea of religion. The second issue is of the people who are already here, who have somehow managed to get into your country, whom you describe as illegal immigrants. Incidentally, there is a strong move to avoid the use of the term illegal immigrants. In fact, the Associated Press has stopped using this. There are many other journalistic organizations which have stopped using the phrase illegal immigrants. They use undocumented immigrants and similar phrases of that sort, but leave that to one side. How have countries in practice handled it? From what I know of internationally, almost invariably the only solution you have when you can't really repatriate these people is amnesty. That you cannot handle people who are already in your country, whom you cannot repatriate except through an amnesty. In 1986, it was Reagan who brought in an amnesty. A right-wing Republican president, Reagan, brought in an amnesty. And I would like to quote what he had to say on why we had to have an amnesty. And this is what Reagan said. I believe in the idea of amnesty for those who have put down roots and lived here, even though some time back they may have entered illegally. Which is recognizing that once people are here, they've been here for decades, perhaps generations, you have no alternative but to regularize the life and position here. Right now in the UK, Boris Johnson has been talking about an amnesty on the same lines. What we are doing in the CAA is an amnesty by religion. We are in effect saying that there will be a de facto amnesty for anybody who is not Muslim, but not for Muslims. In effect, what we are moving towards is something which was there in Germany in the 1930s, in Hitler's Germany, in the Citizenship Act, which was there, where they distinguished between citizens, people who could establish that they were of Germanic origin, subjects who may have been born in Germany, but who could not establish that they were of Germanic origin. This is what was basically to isolate the Jews and, of course, aliens. And in fact, what we are doing by this discrimination on grounds of religion is moving towards that. And this is so huge a departure from the idea of non-discriminating universality that we started with, that to me, whatever the fine legal interpretation may be, in political terms, is a huge, huge departure from the constitution that we started with. So for this reason, I believe this is something that one should oppose. Thank you.
The politics of demography, of national identity, cultural nationalism, and citizenship has always been on the agenda of BJP. But the renewed and repeated emphasis on weeding out illegal migrants, and now through the legal route, as the Home Minister called it, has completely shaken the foundational principles of the society, of the Constitution, and challenged the principles of fraternity. And all the people here on the panel have talked about it. Some of the ideas, if we look at the Citizenship Amendment Act from the standpoint of India's refugee framework, we know that India is neither party to the 1951 Convention on Refugees nor the 1967 Protocol, and thus does not maintain a national refugee law. Without this, the refugee framework of India currently maintains is subject to ever-changing political calculations with an ad hoc approach to different refugee influxes. Some groups are granted a full range of benefits, including legal residence and ability to be legally employed, while others are criminalized and denied access to basic social resources, and we all know which one. The government, for instance, I give one example, includes Sikhs from Afghanistan in its positive rhetoric, declaring that returnees to declaring them as returnees to their homeland. And in contrast, Afghan Muslim refugees who come in recent years using the same lenient visa regime that covered both Sikhs and Hindus, the BJP government seeks to edge them out of the similar protections upon arrival. As we know, all Afghan refugees in India fall under the UNHCR mandate, and the organization UNHCR actually grants them short-term rights to reside in the country, but it is only a long-term visa which gives the right to legally work, attend school, and rent, and not live in the refugee colonies, but rent their own places. Non-Muslim Afghans are immediately eligible for this application, whereas Muslims must enter another hard process to prove they are refugees and not economic migrants. So the Indian government, as we know, has yet to declare any Muslim group legitimate refugees. There are no legitimate refugees that have been declared in India, Muslims. Over the years, with successive amendments in citizenship laws, as we have been hearing this morning, India has been taking a less generous position on the refugee question. An obsession with securitization, which led to militarized borders and changes in laws to make entry more and more difficult, and which is now being compounded by the Saffronization agenda. So we all are seeking some new ideas on what should be, this is a challenge, what should be our refugee policy, if at all? What are we seeking? What should it look like? Let's quickly recall that the modern refugee regime globally was established in the aftermath of World War II, which left some 55 million displaced in Europe alone. The regime contained specific norms and institutions intended to facilitate cooperation and overcome collective action failure in responding to refugee movements. States at that time recognized the right of refugees to not to be forcibly returned to a country where they would face serious harm, and they adopted a definition of refugee, which Gautam described this morning, based on a well-founded fear of persecution on grounds of race, religion, nationality, membership of a particular social group, or political opinion. These were the underlying areas which made the definition of refugees. As a foundation to the regime, Article 14.1 of the 1948 Universal Declaration of Human Rights provided that everyone has the right to seek and to enjoy in other countries asylum from persecution. The 1951 Convention on Status of Refugees detailed a set of refugee rights, which included access to national courts, freedom of movement, the right to employment and education, and a host of other social, economic, and political rights. And more importantly, it said, on par with those held by the nationals of the host country. A significant right in the 1951 Convention is non-refoulement, as the prohibition of returning refugees to the frontiers of territories where their life or freedom would be threatened on account of race, religion, nationality, membership of a particular social group, or political opinion. Non-refoulement remains the cornerstone of the international refugee protection, which actually India failed to uphold very recently when it repatriated 7 Rohingyas who were seeking asylum in India back to Rakhine State last year. The underlying idea of the 1951 convention was that people are forced to flee their homelands, and it is the responsibility of the global community actually to acknowledge this and support them in leading a life of dignity. Currently, globally, these issues are being approached through a new framework which acknowledges the fact that there are over 25 million refugees worldwide, and each refugee is spending a minimum of at least 5 years in asylum, and that 84% of the 25 million refugees in the world are hosted by developing countries, of which 80% are in 8 countries only. So India, if it says that it doesn't have the capacity to host refugees, there are other countries, much smaller, much less developed, which are actually shouldering the responsibility of hosting refugees. There is now a new global compact on refugees, the GCR, which is affirmed by the United Nations General Assembly in December 2018. It mandates periodic global refugee forums where all UN member states, together with relevant stakeholders, announce concrete pledges and contributions towards the objective of the global compact, which include a life of dignity for all refugees with human rights. And they recently concluded a forum in Geneva last month. There's also now a global compact for safe, orderly, and regular migration, the Migration Compact, which was adopted in 2018. Both migration and refugee compacts promise to respond to the human rights of people on the move, to provide conditions for them to live in safety and with dignity, and to empower them to reach the societies in which they live. Such undertakings reaffirm the essence of the Universal Declaration of Human Rights, which was adopted 70 years ago. The Citizenship Amendment Act doesn't reflect a similar moral and political undertaking by the government of India. This law is not desired to respect the human rights of people on the move or to provide the conditions for them to live in safety and with dignity. It's not to express solidarity with those who are forced to flee. It is not even a reaffirmation of the obligation to fully respect the human rights of refugees and migrants, and it is not in support of existing international legal principles. It is not designed to underline the centrality of international cooperation to the refugee protection regime. It is not to include, but to exclude and to potentially disenfranchise, as we've been hearing this morning. So as a framework of global commitment, India's approach is actually myopic and inward-looking, which is pandering to xenophobia rather than the obvious need to manage migration and refugee crisis in a more cooperative, orderly, and humane manner. So migrants who are seeking shelter in India arrive from too many diverse contexts, and they are of too many religions. And for religious differentiation to be the underlying principle is nothing but a disaster. And we have seen that even though India is not part of the 1951 Convention on the Refugees and also of the 67 Protocol, India has voted affirmatively to adopt the Universal Declaration of Human Rights, which affirm rights of all persons, citizens and non-citizens. And therefore, we need to think of a refugee policy which upholds these principles and which for us to be the civilized members of the global community makes us a dignified entry, which at the moment, as we've been hearing, we are falling completely short of. It's just the beginning of, we don't have a refugee policy, and I think we need to start thinking about a more humanitarian policy, which builds on the principles of recognition of the fact that people do not leave their homes, but they are forced to leave homes, and to give them a life of dignity, allow them to lead a respectful, dignified life where they can earn and make livelihoods is the responsibility of the global community, and India must be, as civilized member of the community, should continue to underline it. Thanks.
With the degree of misinformation that is going around today, I mean, it is amazing that, the Prime Minister of the country says things which are contrary to what the President has said, and so on. So this misinformation, well, there are two ways of looking at it. I would commend the establishment for thinking on their feet, so that as people, the urban Naxals like us, as we point out flaws in what they are saying or untruths in what they are saying, they change tack. And what is said yesterday is no longer true today, and so on. There's a new truth. Now, again, I mean, I will come to that in a little more detail later, but let's remember what the policy of Herr Goebbels was some years ago in a Central European country. Now, the other problem is that in the darkness of the evening or the night, as we saw also in Maharashtra, and as has been pointed out, certain advanced steps have been taken administratively, which in fact are precursors to the CAA. And this has gone, whether it's the Reserve Bank or whether it is the refugees from Pakistan coming in, this has gone unnoticed. I will take the liberty of reading out briefly from the jury's conclusions after the People's Tribunal on what happened in Assam over several years. And whether or not Assam itself is replicated, I do believe that we need to keep this at the back of our minds to understand what could happen. I will read out briefly. They noted it is not just mental distress which is killing people. There are inhuman processes involved in the whole NRC, which is forcing people to die in most unfortunate ways. And this is not just like people like me who are generalists and not very educated in these matters, but this is a view of two, among others, of two former judges of the Supreme Court and a judge of the Delhi High Court and other distinguished citizens and lawyers. Literally, millions of people were asked to appear before the verification officers in faraway places multiple times to prove their citizenship credentials. In most cases, the verifications were held outside the home district. People died in the NRC queues, in vehicle accidents, attending arbitrary long-distance hearings on very short notice, and of heat strokes. In sum, the jury would like to emphasize that in the context of Assam, as well as in the country, citizenship as the right to have rights is one of the most basic fundamental human rights in modern societies. Deprivation of citizenship must follow the most rigorous procedure available. The overriding concern must be fairness, not quickness or efficiency. Now, of course, after all these, after people spending months and years and dying in detention centers, which we are told do not exist, now, after all this, when the results did not tally with what was expected, which is millions of illegal Muslim immigrants in Assam, then the whole thing was terminated. It didn't happen. I mean, can you think of the cost? I'm not talking about the financial cost of a few thousand crores, but of the enormous human cost that was paid by people in Assam in pursuit of this chimera. Now, I will digress a little here in the case of Bangladesh. Now, I have no authority to speak on either the people of Bangladesh or the minorities in Bangladesh, but having spent many, many years there and also spent some years in Pakistan, I think I should share some of my views on this. I cannot stand here and say that minorities in Bangladesh have not suffered, certainly. But it is completely untrue to claim, as is being done, that it is a systematic persecution of the minorities in Bangladesh. That's a falsehood. There have been periods, there have been ups and downs. But if we look at the recent past, I would like to share just some figures with you. If I can remember them. The decadal increase in the Indian population from 2001 to 11 was, I think, 17.7%. That in Bangladesh was 17.1%. So they increased less. And even if you translate that to figures, it does not lead to millions coming into India. But here let us also note that the fertility rate of women in Bangladesh is lower than in India. The annual rate of growth of population in Bangladesh is lower than in India. So what the precise figures would translate into, I cannot say, but I think when we do as, unfortunately, our Supreme Court did under the pressures of the Sonowal case some 15 years ago. We have to get over this idea that there are millions and millions and perhaps tens of millions of Bangladeshis populating various parts of India to our detriment, most of them being Muslims. Now, and on the subject of minorities, I also need to say that in 2015, a gentleman by the name of Salahuddin Qadir Chaudhry, socially extremely prominent, politically powerful, an advisor to a former prime minister, he was hanged for his war crimes against Hindus in 1971. There have been other instances of Muslims accused of communal crimes being suitably punished in Bangladesh. Well, what can I say when we look back at our record, be it 1984, be it 2002, or what has happened subsequently? Now, talking of the NRIC that Harsh asked me to speak on briefly, individually, if we look at the CAA, the NPR, the NRIC, each one can be in some way justified, perhaps, except in terms of their being illegal in some cases. But the problem here arises that the new NPR of 2020 is not the NPR of previous years. This NPR has certain clauses relating to our parents. And I'm sorry, but I am not able to accept any assertion by the government that this and that will not be mixed up. I think they will be. And having completed this NPR, having acquired this information, people operating the NRIC will have the authority to pick up names at their discretion for further investigation. And I hardly need to tell you what kind of names those are going to be. So the entire objective, and here again, let me state my view, I think it should probably be shared by all of you. This entire exercise is not about refugees. It is not about Hindus and Muslims and who is coming and who will be given succor. In fact, in Bangladesh, the Hindus are saying that, look, for God's sake, what you are doing will simply give further enthuse people like the Jamaat to come after us. So it is not our concern about the minorities in Bangladesh or in Afghanistan or Pakistan. The objective is to create laws which can be held as a sword of Damocles on the Muslim citizens of this country. And I think that is the danger before us. I think that is the challenge that we have to face in whatever way we can. I was looking at what happened in Germany in the 1930s. You had the Nuremberg laws of 1935, which concluded the process of disenfranchising the Jews. And there are other similarities. We all know that the founders of this current way of thinking in India saw what's happened in Germany of their fatherland, our Pitribhumi, not Matribhumi, though we believe in Bharat Mata, as their icon. Now, it goes further, and I think this needs to be studied by us in some detail. Somebody in the establishment has. When I see this tirade against love jihad, I am reminded of the German laws against sexual relations between Germans and Jews. So there is an antecedent for whatever we are doing. There is a thought process that is going on, and I think we need complete clarity on what the objectives are. Thank you very much.
Hello, my name is Mohsin Bhat, and I will be presenting a brief on the dangers of the National Population Register, or NPR. Specifically, I'll be arguing that National Population Register as a road towards NRC, or National Register of Citizens, is even more dangerous than the National Register of Citizens in the case of Assam. Now, in order to understand the differences between NPR and NRC in the case of India, the All India National Register of Indian Citizens, compared to what we saw in Assam, we need to understand what the process in Assam really was. In 2013 onward, the Supreme Court of India directed the update of the National Register of Citizens in the case of Assam. What did the process look like? Basically, there was an NRC coordinator, which were an office, a department of government functionaries, and all of them collected documents and proofs of citizenship from all the residents of Assam. In short, all the residents of Assam had to submit a list of documents. These lists of documents were common for all the residents of the state. In fact, a list was created, verified by the Supreme Court, and ultimately it was what was presented to the public in Assam. Everybody had to submit these documents. The NRC coordinator verified these documents, studied these documents to see if the documents stood as proof of citizenship in the case of Assam. Now, of course, many people have expressed doubts, concerns, complaints against the process of NRC in the case of Assam. They have argued maybe it was a discriminatory process, it was not efficient enough, certain communities were disadvantaged. But one thing which comes out from the NRC process in Assam is it was a single process, single set of standards applied to everybody in the whole state. And the process, comparatively, was a transparent process because the NRC coordinator and his office were essentially given clear procedures and rules to apply these standards to everybody in the state. Now let's come to NPR, or National Population Register. The first thing we need to clarify is NPR is not census. Census happens and is conducted by the census officials under this act called the Census Act. The data which is collected is confidential, and of course it is used for social planning, for expenditure, for a range of purposes, for distribution of public wealth, and to do planning. But when it comes to NPR, it does not happen under the Census Act. NPR happens under the Citizenship Act and rules. Therefore, NPR is fundamentally connected with the citizenship process. Now, in what way? The Citizenship Act in India was changed in 2003, and a certain provision called Section 14A was introduced. Under 14A, the government was allowed to create a national register of Indian citizens and, if it wants, to issue multi-purpose national identity cards. The rest of the process is not given under the Act. It is actually given under the rules. Now, rules are something which the government of India, not the parliament, but the government of India makes in order to achieve the purposes of the Act. And this is where the National Population Register is found. Basically, in the 2003 citizenship rules, the government of India decided in 2003 that there is a particular way in which the National Register of Indian Citizens can be created. The first step to create the National Register of Indian Citizens is National Population Register. Basically, the census officials have been given an additional role under the Citizenship Act. The census officials will go and make a comprehensive list of all the residents living in the country. Certain information will be collected from them and a list will be prepared. Now, already the NPR manual, which is what the census officials will be following, has been issued. And one of the things which the NPR process will collect is the date of birth of people, the place of birth, their nationality, of course, including the place of birth of their parents. It is very clear that the NPR process is meant to collect information to verify the citizenship of the residents of the country. All right, let's go to the next step. What do these rules imagine? Once the National Population Register is prepared, the government officials, in fact, the junior local registrar government officials, will decide who in this list, who's part of the NPR, is to be considered what the rules call doubtful citizens. The rules say nothing about who will be counted as a doubtful citizen. It could really be anybody, provided that the local government official is convinced that this is a person who does not seem to be an Indian citizen. After that, the government officials will ask this person who they consider to be a doubtful citizen to produce documents to prove that they are citizens. It could really be anybody. So far, so good. Let's go to the next step. After the draft NRC is created through this NPR route, this particular list will be publicized. Basically, the government will invite public objections against people who have been included in the draft of NRIC. Anybody can raise objections against anybody, basically saying that we believe that this person is not an Indian citizen. What kind of objections can be made? What kind of objections can be accepted? The rules tell us absolutely nothing about it. What we have in this process under the 2003 rules, which start with the NPR and then move on to the finalization of NRC, is an absolutely arbitrary process where local government officials are being asked to decide who is a citizen, who is a doubtful citizen, who can be asked to produce documents, what kind of documents would be good enough to prove that somebody is a citizen. Remember that this process is not being given to a court of law. This process is being given to ordinary government local officials without any safeguards, particularly against targeting or against abuse or misuse of the law. Now the difference between the NRC in Assam and the NRC through the NPR route are more or less clear. In the NRC in Assam, for better or for worse, whatever our problems with that process may have been, there was a single standard which was applied to everybody. In the NPR road to the creation of NRIC, there are no such standards. Everybody is not equal. In fact, the local government officials can ask anybody to prove that they are citizens. People can be targeted, people can be victimized. The worry is that if local government officials are given certain aims, certain number of people that they need to identify as foreigners, there would be even more reason for them to victimize people, especially people who are poorer, who are from weaker sections, minorities of all kinds, can be at the receiving end of this complete arbitrary discretion at the hands of the officials. Another important thing is that something like citizenship of a person cannot be left to ordinary government officials. In fact, it should not be left to the government at all. If there is any doubt about somebody's citizenship, there should be a judicial process. It's a question of evidence and a question of rights, especially with something like citizenship, which is nothing but right to have other rights. It is the very foundation of a person's civic identity. And that cannot be left to the government. It has to be decided, if at all, by courts of law. But what we have in the shape of the National Population Register leading up to the National Register of Indian Citizens is complete executive government discretion at the local level to ask anybody at any time to produce documents and then make up their minds about whether a person is a citizen, a doubtful citizen, or a foreigner. That, unfortunately, is what the 2003 rules provide, and that will lead to, I believe, abuse of law and victimization of people. Thank you.
From the 1st of January, the NPR is already being piloted in Karnataka. It's already begun, and it is it is scheduled to start in the rest of the country from the 1st of April. We don't have time. We need to understand, and it is a much greater threat. the Assam, we had many problems with, many of us had problems with what happened for many years in Assam, but Assam was never a communal project. I mean, for me to imagine Mr. Adityanath's government deciding based on a population register who is a doubtful citizen at the level of the Tehsildar, it is terrifying. And I think we need to recognize it. Now, where is all of this going to be resolved? Our refugee policy, whether we'll have a national register of citizens, whether the NPR is a process, is it going to be resolved in Parliament? We've seen political parties across the spectrum, and in this case, barring specifically and honorably the left, we've seen them very shaky in their moral convictions through this entire process. We've seen them making cynical compromises for immediate political ends. And at some level, quite a uplifting observation that they are now following our young people rather than leading them. So after the protests across the country, we hear Mr. Naveen Patnaik, we hear Mr. Reddy, we hear all sorts of people, and even Mr. Nitish Kumar now saying they won't have an NRC. But given the record that they have so far, I do not think that we can have faith that these issues are going to be resolved in Parliament. Now, where's the second place it can be resolved? And that is in our higher courts. And we must approach them. We must approach the Supreme Court. I am one of many petitioners who have challenged the CAA. But I would like to say again very clearly that the working of the Supreme Court in recent years, and it's important that for a democracy, for a majority in a democracy to not turn majoritarian, the Supreme Court has a very critical role. The judiciary has a very critical role. And I think they have failed India's minorities in recent months and years, over and over again, in the Ayodhya judgment, in how they responded to Kashmir, in how they responded to habeas corpus petitions on Kashmir, on how they responded to petitions about students being beaten up in Aligarh and Jamia. So we will approach the Supreme Court, but I don't think, and in the end it is not, I don't think this issue is going to be decided by, was it a reasonable classification, was it not a reasonable classification? It's not a question of legalese that is at stake at this moment, as all of us have been clear about. The third place that it is going to get resolved, I think, is on the streets. And the battle is being fought, and it's being fought in ways that are inspiring for all of us. But I think that there's a fourth place where ultimately this battle is going to be resolved. And that is in your and my hearts. Because it is in the end a question of whether we have allowed hatred against people based on their identities to be colonized in our hearts in the way that has been the project of the ruling establishment over the last 5 or 6 years. And ultimately, I think it is going to be resolved, as I said, not in Parliament, not in the courts, not even on the streets, but in our hearts. And I think that's where this battle has to be most of all fought. The last thing that I wanted to say before we open up to questions is the question of civil disobedience. And many of us across the country are learning, relearning, and young people, it's exciting again to see them relearn what Mahatma Gandhi taught us. If you're faced with a law which is unjust and ruinous, disobey it, he told us, but disobey it publicly and performatively, almost like jaise ek utsav jaisa, in the way that he went to make a fistful of salt, and it became the most iconic moment in our freedom struggle. But there's another part to what he taught us, and that is that there's no point in civil disobedience unless you demand punishment for yourself. So Mahatma Gandhi went to jail for a year for making a fistful of salt, and 60,000 other Indians went to jail with him after they made salt. And I do believe that this is a moment which calls for civil disobedience of that scale, demanding that if anyone is stripped of citizenship rights, if anyone is sent, any of my sisters or brothers are sent to a detention center, it must happen to me as well. And hum kagaz nahi dikhayenge. But the trouble with hum kagaz nahi dikhayenge for a non-Muslim will have absolutely very different consequences from hum kagaz nahi dikhayenge for a Muslim. And how do we all stand together? The last complication in the civil disobedience is the NPR. Because if the NPR is implemented as part of the census operations, as I believe it may well be, how do we then respond? How do we tell our state governments? So the Kerala government has done something very brave and I think very, very important, but it has done an act of civil disobedience. And it is a constitutional crisis. The central government is within its authority to do what it is doing in a very strict legal sense. And the state government is saying we won't cooperate, we won't give our state machinery. Now, if many states do this, the central government is in its rights to dismiss these governments under Article 356, and then will there be another election, and then how many governments will they dismiss, and how many times will they dismiss them, is, I think, a form of civil disobedience for the federal structure that we are going to see possibly unfold. But the complication is, and that's what I want to leave you, is that what happens about the census? Now, if somebody comes into my house and says, ask me a set of questions, can I say I'm answering them to you for the census but not for the NPR? How's that going to work out? Is something that I think we need to think about in this process of civil disobedience. And I do believe that we have to say that as long as you have tainted the census with the NPR, we boycott also the census.